Hi, and welcome back. This week we're going to be covering Chapter 18, Performance, Breach, and Discharge. So we're still talking about contracts, only in this chapter we're going to talk about how we perform contracts, what happens when we don't breach, and how do we know when we're finished. That's the concept of discharge. Before we get into that, though, I have your lawyer joke of the week. And it goes like this. There was a lawyer who was a big duck hunter, and he knew someone that owned some property down in Missouri. So he, with permission, went down to hunt on this land. And so while he was there hunting, a bunch of ducks flew overhead, and the lawyer shot one out of the sky, and it fell down, but it fell down just on the other side of the fence from the property where the lawyer was hunting. So he started to climb the fence to go get the duck. And just about this time, he saw out of the corner of his eye there was a farmer who was on his tractor, who was driving down the fence row. And so the farmer reached the spot where the lawyer was, got off the tractor, and said, "Hey, what are you doing there?" And the lawyer said, "Well, I was duck hunting, and I shot this duck out of the sky, so I was just coming over to retrieve my duck." And the farmer said, "Well," said, this land on this side of the fence is my land. And so the way I look at it, if the duck fell on my land, it's my duck, so I'm going to keep it." And so the lawyer said, "Well, no, I just shot it a few seconds ago. I shot it, so it's my duck." The farmer said, "Well, I think I'm going to keep the duck." And so the lawyer thought, this is ridiculous, and decided to threaten the farmer. He said, this is crazy. I'm a lawyer, and if you don't let me come over and get my duck, then I'm going to sue you." And the farmer said, "Well," I said, "No, you don't understand. We don't resolve disputes that way out here. We resolve disputes like this using the Missouri three-kick rule." And the lawyer said, "Well, what is that?" And the farmer explained it. He said, "Well, the Missouri three-kick rule works like this." He says, one of us kicks the other one 3 times, and then the other one kicks the first one 3 times, and back and forth until one of us gives up. And the one who doesn't give up gets the duck. So the lawyer thought, that's ridiculous, but I'm out here in the middle of nowhere, and this guy's kind of old, and I think I can take him. So the lawyer says, "All right, you're on." So the farmer comes over and says, "I'll go first." So he rears back, he has his big work boots on, and he kicks the lawyer right in the shin. The lawyer drops to his knees, and then the farmer rears back and he kicks him right in the gut, kind of doubles over the lawyer, and then he kicks him one last time right across the face, knocks him to the ground. And the lawyer kind of shakes his head and comes to, staggers to his feet, and he says, "All right, old man, now it's my turn." So he rears back to kick the farmer. The farmer says, "Oh, that's okay, you can keep the duck." Okay, well, let's talk about performance, discharge, breach, and these contract issues. First, we're going to talk about discharge. All right? Before we can talk about it, though, we have to define what contract discharge is and what it means. A discharge is where a party is no longer obligated to perform under the contract, right? We would use it like a verb. You have been discharged from your obligation under the contract. And normally we think about this being discharged after we perform, after we do what we promised to do. But there are other ways that we can receive a contract discharge, and I have them listed here. First, we can receive a discharge by a condition that either occurs or fails to occur. So if a certain condition occurs, then maybe it'll discharge us from a contract. We'll talk about that in a second. Another way to receive a discharge is by performance, by, again, doing what you were promising to do. At the end of your performance, you can receive a discharge. You can also receive a discharge by agreement. This is where the parties to the contract both agree, or all agree, to discharge each other, for instance. Maybe they reconsider, they enter into a contract, and then they both come back and say, this was a bad idea. Let's let each other off the hook. Let's release each other. That could result in a discharge for both sides by agreement. And then last, if there's some legal defense. And we'll talk about what those are. First, let's talk about conditions. A lot of contracts come with conditions. A condition, of course, is an event that must occur before or after a party becomes obligated under a contract. We think of conditions in 2 ways, express conditions and implied conditions. Most of the conditions we think of are expressed conditions. They're conditions that occur in the contract itself or as part of the agreement. And I'll give you an example. This is a contract condition that happens a lot. In real estate contracts, we have express conditions. A financing contingency clause usually goes along with a real estate contract. So let's say you're looking at my house and you want to buy it. And, like a lot of houses, the purchase price is pretty steep. Let's say it's, $300,000. Well, you, like most potential buyers, don't have $300,000 just sitting around. So you'll have to go to the bank and you'll have to get a loan. And so in the contract, what you're worried about is, what if I sign this contract to buy the house and my loan falls through and I don't get approved for my loan at the bank? And if that happens, then I'm not going to have the money, the purchase price necessary to buy the house, but I'm on contract, so I'm going to breach the contract. I might be on the hook for other damages, etc. So what do we do about that? Well, you might want to put in our contract to purchase my house a financing contingency clause or a condition. And the condition could be that you need to be approved for your loan first before you're obligated to buy my house, right? So we might enter into a contract with that condition in it, where the whole contract, the whole purchase of the house is conditioned on you being approved for your loan first, right? And usually that's within a certain number of days after signing the contract. So we have express conditions. Usually you can spot them because they begin with the words like if, or provided that, or so long as, okay? But then there's sometimes implied conditions too. These are conditions that are sort of implied in the contract itself. So let's say you have a lease, and under the lease it says the landlord agrees to make all repairs necessary to the plumbing in the apartment. Well, implied in that is that the tenant will notify the landlord if there's a problem with the plumbing, right? The landlord wouldn't just automatically know. And so an implied condition in the lease would be that the tenant will notify the landlord if there's a problem the landlord needs to fix. Okay, another kind of distinction we make between conditions sometimes is a condition precedent and a condition subsequent. A condition precedent is where there's an event that has to happen before a legal duty arises. Okay, so this is a condition that must take place or happen before a legal duty attaches. Right, and like I mentioned, my financing contingency clause in a real estate contract, that's where one party has to be approved for their loan first, precedent, before that person then is obligated under the contract. And that's how we think of most contracts, as contracts precedent, an event that must occur first. But sometimes contracts can include conditions subsequent. So this is where the parties are obligated until or unless an event happens after the contract is entered into that might release one party. So it's a condition subsequent to the making of the contract that would release one or both parties, right? And on the slide here we have an event that must happen after duty arises that will discharge the duty if it does or doesn't occur. The best example of this might be with insurance. An insurance contract sometimes may be a property insurance policy, where I buy a policy of insurance and the insurance company agrees to cover my house and my buildings from a loss. And usually it will include a condition subsequent. And the condition will be that I will file a proof of loss or a claim within a certain number of days after I suffer the loss. And if I fail to file a claim within a certain number of days, then the insurance company is discharged from having to cover that loss. Right? So if I have a property insurance policy and there's a tornado that destroys my garage, and the language of the policy says that I have to notify or file a claim within 90 days of my loss in order to have it covered. If I wait 120 days and then file my claim, well, then the insurance company might say, we're discharged from our duty to have to cover your loss because there was a condition subsequent. Right? You didn't meet the condition of filing the claim within 90 days, and therefore that condition triggers and we're discharged. We don't have to cover that anymore. And you might be thinking, well, really, who cares if it's a condition precedent or a condition subsequent? Sometimes it matters, especially when we get into court. And I've got an issue there on the slide about the burden of proof. We used to read a case in this chapter of our textbook, and they've taken it out since, that was about an automobile insurance policy. and it covered, your normal accidents, but it had some language in it that said that the insurance company would only pay for personal injury to the insured if the insured was wearing a seatbelt. If the insured party was not wearing a seatbelt and was injured, then the insurance company didn't cover the claim. So there was an accident, an automobile accident. This policy was in question. The police investigated the accident, and there was absolutely no evidence about whether the insured person was wearing a seatbelt or wasn't wearing a seatbelt. So the parties got into court. The insurance company refused to pay the claim, saying that the insured party wasn't wearing a seatbelt, so they weren't required. And when they got into court, the issue came up: is this a condition precedent or is this a condition subsequent? And who cares? Well, the court said it matters because if it's a condition precedent, then the plaintiff had the burden of proof. In other words, the plaintiff, the insured party, had the burden of proving that he was wearing a seatbelt. Whereas if it's a condition subsequent, an event that would release one party, like the insurance company, then the defendant or the insurance company had the burden of proof of showing that he wasn't wearing a seatbelt. And since there was no proof either way, who had the burden of proof on this issue was going to determine who won the case. Well, in that case, the court decided for several reasons, one of which was probably that they had some sympathy for the insured party and their injuries. They sided with the plaintiff, with the insured, and against the insurance company. And they said that that kind of language in the policy was a condition subsequent that the insurance company had to prove. Okay, let's take a look at performance as a means of discharge by performance. And there's some terms that we have to be familiar with here. First is just generally a term that's related to contracts that I want us to be familiar with, and that's the verb tender or to tender, right? When we offer up our performance, we say we tender our performance. Another way of saying this, you might have heard, is that a party appears and is ready, willing, and able to perform. Right? So if the contract requires delivering certain goods, I show up at your doorstep with the goods, ready, willing, and able to give them to you. I've tendered my performance. Okay, now, this is just a term I want you to be familiar with and what it means, because we're going to talk about it later on, especially when we get into some issues with the UCC. But it has to do with our performance. Another couple of terms I want to be familiar with here is complete and substantial performance. Now we're going to talk about the types of performance that you can offer up under your contract. So complete performance, or what we call perfect performance, is just like it sounds. This is performing your contract exactly as you've agreed, fulfilling all the requirements. So if you're going to come paint my house and I'm going to pay you $500 on Saturday, you come paint my house, I pay you the $500 in cash on Saturday. I have given you complete or perfect performance, and performed exactly as I promised. Now, the reason that we bring this up and mention this is because if you give complete performance under a contract, you receive a discharge. Right? And this may be obvious, but if I do everything I promised to do under the contract, then I have nothing left to do under the contract. I'm no longer obligated, and I receive a discharge. Now, this is important because the law doesn't require complete or perfect performance in every contract. Because as we can see here, there's another kind of performance called substantial performance. Substantial performance, this is a concept that we use a lot of times when one party is giving personal services under a contract. And as you might have guessed, sometimes it's difficult or impossible even to give perfect performance if your performance is personal services. So think of a construction contract. This is a good way to look at substantial performance. If you're the builder, let's say that you sign a construction contract, you're going to build an office building. It's a 20-story office building, and there are blueprints with exact measurements, and you agree that you're going to build the 20-story office building exactly according to the blueprints. Well, what are the chances that when you get finished with your construction, even if you do a good job, that when you stretch out your measuring tape, that every wall, every window, every ceiling will be exactly the measurements required in the blueprints? So if the wall is supposed to be 20 feet long, that it is exactly 20 feet, not 20 feet and 2 inches, right? Well, it would be virtually impossible to give perfect performance under those conditions, right? Because people are imperfect, materials are imperfect sometimes, and it would be nearly impossible to do that and give complete or perfect performance. Does that mean we breach the contract? Does that mean we never get a discharge? Well, no, because the law recognizes substantial performance and will give us a discharge if we give substantial performance. So let's take a look at what that would be. Substantial performance is a good faith performance that provides a party with the important and essential benefits of the contract despite some minor deviations. Okay? We used to read a case about substantial performance where there was a builder and who built a home for a person, and the contract required that the builder use a specific brand of pipes for the plumbing. And when the house was completely built, it was determined that the builder didn't use 100% pipes of this brand. There were some that were another brand. And so the owner refused to pay and said, no, this is a breach of the contract. Contract clearly said that, you know, you had to use this certain brand of pipes, and so therefore I'm not paying. They ended up in court, and the court recognized substantial performance and said, well, the pipes that were used, no, they weren't the brand that was called for in the contract, but they were rated the same, they were the same quality, the same thickness, even the same price. And the court ultimately said, well, they're really the same thing. And even though the contractor didn't give perfect performance, the contractor did give substantial performance. The mistake that was made in good faith, which means the contractor wasn't trying to pull anything over and using the wrong ones on purpose. It was an honest mistake. And the owner got the substantial benefits of the contract, got a house with plumbing of a certain quality that worked. And so the court made the owner pay for that. Even though it wasn't perfect performance, the court recognized substantial performance and allowed the contractor to be paid and discharged. Let's take a look here at what courts will look at in determining whether a party gave substantial performance or not. Courts will look at the following factors. First, how much benefit was received? Now, let's use my example of the homeowner having the house built. How much benefit did the homeowner receive? Well, really, virtually all the benefit that he tried to get under the contract. He got a house with plumbing of a certain quality that was functional. And so he got really a lot of the benefit, almost all of the benefit that he contracted to get. Second, can the owner use the thing for its intended purpose? Well, like I mentioned, in our example, yes, the homeowner could use the house for its intended purpose and the plumbing. Basically got essentially what he contracted for. Can the promisee be compensated with money damages? If you give less than perfect performance, would money damages compensate you adequately? So in the case that I mentioned, the court said that the contractor had to make up for the deviations, those differences in the contract, but only had to make up the difference in value. In other words, the difference in value between the brand of pipes that the contract called for and the type that were used. And actually in that case, the court said that the difference in value was zero because they were almost literally the same thing. And then last, did the promisor act in good faith? Again, did the party who gave the substantial performance make the minor deviations in good faith or bad faith? And in my example, did the contractor use the different pipes on purpose, trying to slip something past the owner? Or was it an honest mistake? And those are things that the court will look at to determine if someone gave substantial or good enough performance. Okay, last here we'll talk about good faith. I've mentioned it already in the context of substantial performance. All contracts really are required to be performed in good faith. The UCC, as you can see here, requires good faith, and the common law, in the Common Law Restatement 205, require every contract imposes a duty of good faith and fair dealing. That's how the code and the courts refer to it. What does that really mean? Well, in operating in good faith, the party must allow the other party to perform and not unreasonably interfere with their performance or make it difficult or impossible for the other side to perform. And if they do that, they may not be operating in good faith. I have a real-life example of this really quickly. I represented a local building contractor who was repairing a roof for a lady's house. And they'd signed the contract, and the contractor went out and started performing. And it was a small house, and really the whole project was only going to take maybe 2 to 3 days to finish. And the contractor got out there with his crew and they started pulling the shingles off. And the homeowner came out and stopped him and complained about the way the shingles were being ripped off of the roof and where they were being placed and what to do with the old shingles and all these things. And so she called the building inspector for the city to come out to make sure that the contractor was doing things according to the building code. Building inspector came out and said, no, everything's fine. This is the way you remove shingles from a house. So the contractor got back up on the roof, started performing some more. The owner came out again, same day in the afternoon, stopped them again, called the building inspector. Building inspector came out and said, no, everything is fine. Second day went on like this. The third day, the fourth day, she called the building inspector no less than 7 times in 3 days. And finally, the builder, some of the workers on his crew just quit. They went home and said, oh, we're not going to work under these conditions. Every time we get up on the roof, we have to stop and come down. And he was just hiring guys by the job. And they said, forget this. I'm going to work for somebody else. And so eventually, the builder had to stop. One thing led to another. We ended up in court over the contract. And one of the claims of the contractor was that the homeowner had not operated in good faith. In other words, violated this duty of good faith and fair dealing by continuously and really without reason interrupted the performance, making it much different, much longer, much more difficult than the contract originally anticipated. And ultimately, the court agreed. Calling the building inspector, a couple of times under the circumstances in the case would have been reasonable. But 7 times in 3 days when the building inspector found 0 violations ultimately led the court to conclude that she was not operating in good faith and unreasonably interfering with their performance.